Welcome to The Point of View. This is your favorite current affairs show on television. Tonight on The Point of View, we have a big conversation, controversial ambulance case that has gone outside the court. NDC holds a press conference commenting on a tip that they've aired, the role of the AG. They are asking that he resigns. MPP will have none of that. We'll be speaking to three people on this case. We'll speak to lawyer Roxin Echedafe-Amekpo. He is the Member of Parliament for South Dai. We'll speak to him. Nana Buachi. He's also a lawyer, national organizer of the MPP. And then we'll speak to Professor of Law to get his views on this controversial matter. Stay with us. The Point of View tonight is looking at the latest in respect of the ambulance case. Atu Forson is the minority leader, MP for Ejuma Kwenyani Siam. He's first accused in a case of causing financial loss to the state, together with two people, former Chief Director, Ministry of Health, Mr. Animana, who in March this year had charges dropped against him for want of evidence. But there's also a third accused, Richard Jakba, who is still on trial. It's fact, it was during the cross-examination of Mr. Jakba that he gave an outburst in court about the attempt by the Attorney General to influence the way he gives his evidence. This has led to so many developments. This was last week. This week we've had the NDC, led by their national chairman, hold a press conference live on TV and radio, spell out 4 issues against the Attorney General. He accuses the Attorney General of essentially trying to tamper with a witness, of fabrication of evidence to pervert the course of justice, professional misconduct, and conspiracy against an accused person. So the key characters in the case, Kaselatu Forson, as I said, on your left, Attorney General is the leading lawyer on the prosecution side on this matter. First accused, Atu Forson, is on your left. When the case began, he was the minority spokesperson on finance, ranking member on the finance committee. Now he's the minority leader. Second accused, Ministry of Health Chief Director, former Dr. Sylvester Animana. And he, in March this year, had charges discontinued because there wasn't enough evidence. He's the second accused. Third accused, Richard Jakba, who is the local rep of Big C's, a Dubai-based company that supplied the ambulances. There were supposed to be 200 of them. The main issue here is the accusation against Atu Forson is the payments were made after letters of credit issued before the ambulances came in, and also that the ambulances themselves were not proper ambulances, that they were basically substandard and that they did not function at all. And by the actions of Mr. Forson, he's got financial loss to the state. He's defending himself. He says everything he did, he had the express approval of his boss, the then Setekwe, who also testified in court to confirm what he said. Alex Agbesfe is also here because he was the Minister of Health at the time, and there is a communication suggesting that he did not think the ambulances were needed. All of these people have been spoken to. That's where the case is in court. We don't want to go into the details of the case because that's the purpose of this program. What we want to look at is where the latest exposés, the 16-minute tape played, where this leaves the Attorney General and where this leaves the case. Let me talk to MP for South Dai, himself a lawyer, the Honorable Roxin Echedafe-Amekpo. Honorable, thanks for joining the program.
Thank you very much, Bernard, and good evening to your viewers.
So as I said in my prelude, I don't want to go into the substance of the case yet because it's in court, but there are 2 key questions. Where does what we know so far leave the Attorney General? And then we get into where it leaves the case itself. I've heard the NDC say he should go. Is it he should go as Attorney General, or he should go for now as the lead lawyer on the case? Just explain to us the NDC's position.
Thank you very much. The NDC is firm in its conviction that the Attorney General ought to leave, must leave as an Attorney General qua Attorney General. Because if, as aggrieved parties or as one of the accused persons charged in this matter, Honorable Kaselatu Forson, if he decides to be aggrieved by the present conduct of the Attorney General as revealed by the third accused person, Mr. Richard Jakba, if he decides to petition against the conduct of the Attorney General to the General Legal Council, There's danger that his petition may not receive fair hearing by reason of the fact that the Attorney General is statutorily represented on that committee by virtue of being the occupant of the office of the Attorney General. That's the first basis. So he cannot stay in office for a petition seeking to look into the matters that presently surrounds him to be given a fair hearing. So he has to leave. Two, the Attorney General's conduct does not only border on professional misconduct, which if you refer to the LI 2423 enacted in 2020, which he himself appeared before our committee in Parliament to actively sponsor through the enactment process. Regulations 8, Regulations 13, Regulations 40, 35, 30, 56, 57, and 53, 67, 72, 82. All these are specific regulations contained in LI 24, 23, 2020 that the President conduct offense extensively. But for lack of time, I would have read out these specific regulations as contained in the LI, but I've made reference to them. So at your own time, you can have reference to them when you are done. And it will establish clearly that every single conduct of the Attorney General breached any of this extensively. And so on that basis, he cannot be deemed to continue in the role of the Attorney General for the Republic of Ghana and Minister of Justice for the Republic of Ghana. Again, his conduct also amounts to fraudulent misconduct. It also amounts to a conduct that is unbecoming of an Attorney General. It also amounts to tampering with a witness, and it also amounts to subversion of the cause of justice, which are all criminal offenses. So in addition to having a complaint before the General Legal Counsel, the NDC is convinced that a proper investigation, criminal investigation, ought to be undertaken into this matter. And the Attorney General, inherent in the Attorney General are the powers contained in Article 88 of the Constitution. And he exercised these powers as he sees fit, including the power to exercise nolle prosequi. So if the Attorney General is inherent with the power to discontinue criminal cases that are under prosecution, then our fear is that this investigation may not even see the light of day. So his continued stay in office is a danger to having these investigations conducted first of all and leading to some proper prosecution. So in all the perspectives surrounding this matter, the Attorney General cannot, he does not even have the confidence presently at the bar as the leader of the bar. He doesn't have the confidence of the bar to lead the bar. So he has to go.
But can we?
And above all this,
okay.
And above all this, Bernard, is the dragging in the justice of the Supreme Court, Justice Yoni Kulendi. And I made the call this morning earlier that it will be proper for the Judicial Secretary to issue a statement regarding the alleged role of Justice Yoni Kulendi in this matter. Because if you read the code of conduct for judges and magistrates of the Republic of Ghana, if you read Rule 7 under the first principle of integrity, Justice Kulendi, if his role is established, he would have offended that rule. And again, if you read rule 1 of the principle and the integrity, his conduct would have breached that code. And so 2 codes contained in the judges and magistrates, in the code of conduct for judges and magistrates of this country, the alleged conduct of the alleged role of Justice Yoni Kulendi offends these 2 codes. And when that happens, the consequences can be grave for him. So the silence of the judiciary or the judicial secretary on this matter is further harming the image and integrity of Justice Yoni Kulendi. And his name was put out first when I first heard of his role. That it was a supposition, but the mentioning of his name actually was done by the NPP, the organizer for the National Patriotic Party, Nana Boachi. He wrote on social media and mentioned his name.
But did the mention of his name suggest any wrongdoing?
This is not a matter. It's become such a major issue that cannot be handled whimsically.
I was going to ask if the mere fact that Nana Boachi mentions his name and the fact that his home was supposedly used for a meeting, is that enough to necessitate a comment from the Judicial Secretary? Because I did not hear the NDC directly accuse Justice Kulendi of anything, if I'm not mistaken.
Yes, the NDC hasn't done that, but we as petitioners, I am raising that perspective. That you see, as a judge, he is barred from even permitting any contact, ex parte contact with a witness who is testifying before a court or who is supposed to appear in an impending proceeding before a court. As a judge, he's barred by the code of conduct. Is not permitted to do that.
Okay, let me talk to Henry Nana Boachi, who is the national organizer of the New Patriotic Party. He's a lawyer, an officer of the court himself. It appears that the last point you made about the justice of the Supreme Court emanated on his Facebook wall. So maybe let me start that with him before I take his general comment. Lawyer Boachi, thanks for joining us on The Point of View.
Good evening, Bernard.
Yes, how are you, sir?
Oh, I'm good. How are you too?
I'm very well. Before we get into the substance of the leak tape and all of those, I think you said on your Facebook something to do with the venue of the meetings between the Attorney General and the third accused, Mr. Jakpa, having occurred in Justice Kulendi's house. What were you really trying to communicate there, and what was the point of putting that out?
Oh, it's because, look, the only times where the Attorney General had communication with Mr. Jakpa, the very first time, and yesterday the NDC, they were disingenuous. You know, they showed a WhatsApp chat which sought to illustrate how the Attorney General is to make a certain arrangement for a meeting. But then after this, I will send you the full chat. In fact, the Attorney General did not even have, at that time, he didn't have the person's contact. So it was Mr. Japa who introduced himself as, "Hello, my brother. This is Richard Japa, the brother of Justice Kulendi. Please, I would want to have a private meeting with you." Then the AG said, out of respect for the respected Justice of the Supreme Court, the AG responded by saying, "I will arrange through your brother." But yesterday, you noticed that the NGC, in one of what is supposed to be their evidence, they had edited and cut out the portion where the guy introduces himself as brother to Justice Kulendi. So the periods where they had contact, one, it was in Justice Kulendi's house, he went to visit him upon the request from Justice Kolende, and then the AG went there. Shortly afterwards, then this gentleman walks in. Then few days after, they were supposed to go for a hearing. And in the morning, that is where this telephone conversation happened. So that is what I was trying to illustrate, or that was what I was trying to portray. So I brought out the fact that it is not as though it is the AG who made contact or who approached Mr. Japa. Never. Because Mr. Japa kept saying, or in one of his testimonies to the court, he said that he's been receiving calls from the AG at midnight and all of that. Complete lie. But he said it in court. So I was trying to tell the whole world that, look, if any meeting happened and if anybody even requested for a meeting, it was Mr. Japa who requested it and introduced himself as a brother to Justice Kolende.
Okay, so you are saying this is in terms of the first time the two men spoke, it was at the instance of Mr. Japa. But,
yes.
But in terms of the audio that the NDC played, the conversation speaks for itself, doesn't it?
Hello?
I'm saying that the 16-minute conversation that was aired, which most of us have heard, I'm sure you've heard it, that conversation speaks for itself in terms of what the AG was trying to do, doesn't it?
No, you know what? You also remember that they indicated that the conversation lasted for 28 minutes. Then I've asked yourself why they cut out 10 whole minutes and only played 16 minutes, because the conversation has started from somewhere. And that conversation in the morning is a continuation of the third meeting they had, because you see, all of these things were about the plea bargain and the pre-negotiation. And when you have plea bargain or pre-negotiation, there will be contacts. And that is the main reason why he called for the intervention of Justice Kolende. In the house of Justice Kolende, the respected justice asked the Attorney General, how far with the plea bargain or plea negotiation? So that is why we are saying this tape is heavily doctored, heavily manipulated. It is cut and pieced together to achieve a certain malicious intent.
So do you have the full 26 minutes?
No, obviously the AG is not recording it. The AG will not be recording it. But the fact is that, ask yourself, why is it that you said that you have a voice? Okay, good. You also showed that it was 28-minute conversation. Good.
No, it's 26.
How come you played only 16?
26.
26 years. How come you played only 16? And 10 minutes is a lot.
Fair enough. But Nana, even if it's a shorter version of a longer tape, from my layman understanding of the way plea bargaining works, it doesn't happen on the phone with just the lawyer and the client. We understand that the lawyer of the person seeking the bargain, there are rules around plea bargaining, and it's a recent law which the
then at that moment, Mr. Japa had disengaged his lawyer. In fact, he had changed lawyers 3 times. At that moment, when they were even having that meeting in the house of Justice Kolende, he did not have representation. He had disengaged his lawyer. Throughout that period, he did not have. In fact, that was even the very reason why the AG was engaging him on adjournment. And this is very normal. And again, I've mentioned that, Bernard, anytime an accused person introduces plea bargaining or plea negotiations, there will be contact, because you need to have several contacts, several agreements, several talks, understand what is going on. Then you reduce it into writing, and then you will bring it before the court. Then the court will either endorse it, or the court will also make its own views around it. Then it becomes binding. So at that moment, I'm telling an authority, and the court records will show that he had disengaged his lawyer. In fact, it was on the morning of the hearing that day when a new lawyer introduced himself as the lawyer for Mr. Japa.
But the fact that a client has disengaged his lawyer, does that make it right for counsel on one side to directly speak to a suspect
It is normal.
in the manner in which the conversation portrays.
Even Ben, I was even surprised because you see, the impression created out there was that they were going to show a certain tape, right, which shows the attorney general directing the person what to say, how to say it, when to say it. In fact, they had even put it out there that he was even telling Mr. Japa to implicate Atufosin. That is what we're made to believe. That is what we're made to believe. But clearly, I've listened to the tape, even the doctor tape, the heavily manipulated tape. Nowhere did the attorney general direct Mr. Japa what to say.
But if you listen to Attorney General, for example, talk about an excused duty and the fact that he would not be in court, and was sort of suggesting to Mr. Japa to either stall the testimony or find a way of making sure that the matter delays until he comes back. Is that not sort of trying to even mislead the court? Because there was no indication in the conversation that the man was not
well. Let me
well.
explain to you again.
Yeah.
That is the more reason why they cut out the 10 minutes. Let me explain to you. Now, before all of these discussions came up, Mr. Japa himself had mentioned to the Attorney General on phone that he's not feeling well. He even intends to go and visit this doctor. He's not well. But then the last time he was not fit, because throughout the court proceedings, all the time he's not been fit. And then the judge issued the bench warrant. So he had already mentioned to the Attorney General that he's not feeling well. So the Attorney General promised his advice on the fact that, yes, if you're not feeling well, but that place was heavily edited and pieced together to create the impression that it is the Attorney General who is telling him that go for an excuse duty. But earlier on, you had mentioned that you are not even well.
Okay, just a final point, because I have Roxanne Dafiamekpo on the line as well. When somebody is talking to somebody and says, hey, I don't even know if I'm being recorded, now does that not suggest to you that he felt that either the conversation was inappropriate or that what he was saying ought not be said? Because it got to a point when they were talking about getting my point of view or getting my side of the argument that he sort of double checked and said, I don't even know if I'm being recorded, so let's end it here. Is that not in itself some self-incriminating in terms of the flow of that voice clip?
Ben, do you know what? At a point, you could see that Japa, because of his malicious intent and because he was recording, he kept saying things that, you know what, this is going to be unfair on my part. I'm not going to go through this ordeal. I cannot allow somebody to go through this ordeal. If I accept a position, the president did not tell you to accept any position on the tape. He never. He said, let's go by this theory. Because they were having discussions as to what, constitute the time for payment and what do not constitute the time for payment. Because as I said, they had already, all of these things were premised on the plea bargaining and plea negotiation. Right? So at no point. So immediately then the guy entered into that move. You know what? If I accept this, I will be implicating Atufosin. I don't want him. And then because he knew what he was doing. And that is at that point, you notice that the Attorney General was very quiet. And he said, somehow, all the things that you are saying, it looks like, is it that somebody is recording? Because clearly, if you listen to me very well, you could see that there is a man on an agenda, a man on a dangerous path. He's recording, so he wants to bring certain things out so that you say something. But the Attorney General did not say anything. But to say that, I will not say anything, but what if somebody is recording? At that time, he was alerted. Because for me, the entire tape they played was harmless.
Okay. Nana, please stay on the line. I will take a comment or two from Roxanne, the NDC MP, and then I'll come back to you to wrap up. So, viewers, this is the point of view. We are on the line with Henry Nana Boakye. He's a lawyer and the national organizer of the MPP. We also have lawyer Roxanne Nelson, Echi Dafiamekpo, MP for South Dai, on the line. When we come back, we'll take two comments. Stay with us. So welcome back to The Point of View. We're still on the issue around the tape that was aired, the NDC's call for the Attorney General to resign or be sacked, and the various issues around the ambulance case. Honorable Roxanne, I'm sure you've been listening to Mr. Nana Boachi, Nana B. What's your response to some of the key points he raises around the fact that if you said you have a 26-minute voice, why are you playing just 16 minutes? Okay, and then why did the WhatsApp messages that you put out as a party not include the first message of the man introducing himself to the Attorney General? And quite a number of things, I'm sure you heard him yourself. What's your response?
Yes. One, it is not our law. In our criminal jurisprudence, it is not our law that where a person is recorded and the evidence is tendered, you question the source of the evidence. So, for instance, the argument that the AG didn't know whether it was being recorded or not is neither here nor there. The rule is that where the evidence is material to a matter in issue, the evidence will be admitted pursuant to Section 51 of the Evidence Act 323. Then the court will place the probative value that it desires on the evidence. So if it claims that the tape was for 26 minutes, it is not up to NDC to play all the 26 minutes, because the 10 minutes, that is the outstanding 10 minutes, the information there may not be relevant to the issue we are raising. So the NDC decided to play exactly 16 minutes of the recording that is germane to the professional misconduct issue that has come up. So that's one. Two, is Nana saying that during plea bargaining there can be ex parte communications with the party, whether or not he's represented in court? It cannot. You should check the law. That is not the circumstances under which you make contact during plea bargaining. So the plea bargaining argument by the NPP falls flat. In any case, how do you hold a plea bargaining discussion in the home of a judge? Is the judge part of the team that is handling the plea bargaining? You should check the law whether there's a role for a judge before it is submitted to a court of law. It is not. So the whole issue is about making improper contact with an accused person who is testifying under oath in court. Now, Nana should tell me that it is right for an attorney general to contact a witness that is still under cross-examination, or that will be cross-examined in an impending matter before a court, or before a proceedings that is before a court. Three, Nana is saying that the issues against the Attorney General are not weightier. They are weightier matters. They are weightier matters. Why? Because the Attorney General is the leader of the bar. And the professional standard expected of lawyers is, in fact, in respect of the Attorney General, supposed to be on a higher pedestal. So if you have an Attorney General who receives a text message from an accused person in a case that he's prosecuting, in fact, the third accused person, who is even asking for a meeting, if I were the Attorney General, and reasonably so, I won't answer. I won't permit such a meeting, because it will be improper. But the Attorney General actually answers Jakpa and says that I will arrange that through your brother. So the meeting in question may not have been arranged by Jakpa. It may have been arranged by the Attorney General by his own admission, the text message. So the issue that it was Jakpa who arranged the meeting in the home of his cousin is neither here nor there. By the evidence, is the Attorney General that arranged the meeting. That is why he claims to have been surprised that Jakpa walked into the meeting. And the Attorney General has not been candid with the whole country. On the 24th of May, he issued a statement under his signature and said that he has never met Jakpa. Then the next day, 25th of May, through his PRO, he says that yes, they met, but they met in the home of a Supreme Court judge, name withheld. All right. Then subsequently, today, my brother Nanabi says that the Attorney General has not denied his voice. If you have not denied your voice, then which portion of the recorded message are you suggesting, or are you alluding to the fact that the NDC cut and merged?
Yeah, but let me make that point. When he says, for example, that Jakpa had said earlier in the conversation that he was not well. So when the AG in that conversation was talking about sort of medical excuse, if that part of the conversation which Nana is saying was taken out, was there, a reasonable listener would know that the AG is asking for this because you already told him you are not well. This is what he's saying.
Yes, but Bernard, as an Attorney General who is prosecuting this third accused person, are you the one who will be advising him as to what to do? Like lawyers do, you will say that you know what to do. You don't come and tell me, AG, that you are well, so I guide you what to do. I'm not a lawyer. In any case, didn't the Attorney General say that then they should delay the hearing so that he could travel and come back? Didn't he say that on the tape? So Bernard, the argument that this tape has been doctored, and they are not able to establish it. One, you admit that is AG's voice. You admit that the WhatsApp communication took place. Your worry is that instead of 26 minutes, we are relying on the content of 60 minutes duration. So you are bothered. Maybe the content in the 10 minutes will border on treason. So we don't want to play it. What we want to play is the content of the 60 minutes that is germane to the matter in issue. So Nanabi, as a fellow legal mind and as a fellow officer of the court, he must join me in this and ask the AG to step aside so that we can look into this matter properly.
Let me take his response.
And let me top it up by saying that this Attorney General himself has called for the interdiction of a lot of public officers in this country for allegations of commission of a crime or for some professional impropriety, and has launched investigations into the conduct of these public servants, and he's in court prosecuting some of them. How come that when he himself allegations are made about his professional conduct, we think that he should stay on? He must go home. He must stay aside so that the proper thing can be done.
Okay, thank you. Let me take Nanabi's response to this. Nanabi, I'm sure you heard Honorable Roxanne. What's your response?
Oh, yes, I heard my senior. I mean, first of all, I do not think that the communication that happened was ex parte. That is number one. Number two, I've also told you that on the record, and it's there, the court record, Mr. Japa was without representation when that conversation happened. Again, I've also said that this manipulated and doctored tape, Bernard, they should put the entire tape out. Because a lot of revelations are captured within that 10 minutes. They have decided to cut out. A lot. Again, let me say that if that had been their intention all this while, because the Attorney General, he has finished his case. He has closed his matter. In fact, he has put before the law court whatever relevant evidence he has. In fact, at the point where he finished, they made a submission of no case. And the court rejected it. And the court directed that they should open their defense. What the court simply is saying is that, look, a prima facie case has been established against you to open your defense. So if they think that they're going to make all of this noise outside the law court so that his leader in parliament will be shielded from accountability and responsibility, then it will not happen. Look, the Attorney General will not resign today. He will not resign tomorrow. In fact, we believe that His Excellency, the Vice President, will be next President of Ghana. In fact, even if he appoints him as Attorney General, he will continue. He is one of the best Attorney Generals in fact. So if you go behind this machination, this orchestration, It will not work.
But Nana, in terms of...
And again, let me say,
okay,
there are appropriate platforms to address these matters. The matter is already in court. Bernard, are you aware there is a motion for mistrial before the court?
From
Bernard,
who?
Yes. No, yes, the Atoforces, that is accused persons, A1, A2, A1 and A3, they have filed a motion for mistrial. And the attachment, the evidence they attached, interestingly, did not include this voice, the tape they played, interestingly. Because that is supposed to be your main trump card. Is that supposed to be your weapon, your main weapon? Why is it that you don't attach it to the motion for mistrial in court? Because you know what, Bernard, this tape will not stand the test of time and credibility in the law court. Because the moment you present it, we will subject it to forensic audit. And it will emerge that it has been massively and heavily manipulated, doctored, it's been cut and pieced together to achieve a certain mischievous intent. So there we have the platform. So yes, I agree with Honorable Dasiamako. Yes, if they think that there's a matter, they can go to the appropriate quarters. They can do so. But the AG will not resign today. The AG will not resign tomorrow. He's going to continue his work. He's going to make sure that Atoforsen will answer. In any case, I'm happy that they have not said that the judge sitting on the matter is biased. No. So when I hear that people peddling political persecution, I wonder. Because everybody will have his day in court. Nobody is persecuting anybody. If you have a strong case, then bring it. How come they introduced plea bargaining and plea negotiation? Because what? You know that your case is weak. So we are going to pay 2 million euros. I don't know whether then you have all these documents. I can forward them to you.
But the plea bargain, as we know, is from the third accused. The request is not from the first accused.
In fact, the first accused even wrote a letter showing he has no objection against the plea bargaining.
But the plea bargaining for the company that the third accused represents.
Yes, that is what I'm saying, that A1 wrote a letter to the AG indicating that they have no objection. If you have no objection, it means you don't have any problem with it. It means you're okay with it.
Yeah, but he's not the one.
Why?
He's not the one asking for the plea bargain. He's been straining to make that point that he's not the one requesting for the plea bargain.
In fact, the Attorney General even wrote back for clarification that are you by this saying that you are associating yourself so that the Attorney General will know the parties he's dealing with regarding this plea bargaining. And then he went back to say no. You know why? Because for plea bargaining, anytime you introduce it, there is that seeming intention that there's an admission of guilt. There's an admission of wrongdoing.
So he says no.
So, yes. So, cleverly, he wants to run away from it. So he wants it, but he doesn't want it. He doesn't have any problem with it, but he would not say that he's associating himself with it. So that it will be said that it's an admission of wrongdoing, it's an admission of guilt.
All right. Nanabi, thank you for your intervention. Thank you, Roxy Nelson.
Bernard, I have a point to make.
Okay,
a quick one.
30 seconds, please.
Let me refer Nana to Rule 82 of LI 2423/2020, and it reads as follows: 82. A lawyer shall not A. quote a witness in relation to the evidence of the witness. B. Encourage a witness to give evidence which is untruthful or which is not the whole truth. C. Communicate directly or indirectly about a case with a witness once the witness has begun to give evidence and until the evidence of the witness has been concluded, except with the consent of the representative of the opposing party or of the court. This is the law. And let me quickly refer you to Rule 67 of the same law. Rule 67.
So you just
And
read
it's
it
very
and
clear that
just read it and leave it there. We won't elaborate for time.
very well, very well.
Just read
Very
it.
well. So clearly, but when my brother says that what the Attorney General did was not wrong, he got it wrong in law. The law forbids what he did.
All right. Thank you. We've been speaking to Roxanne Nelson Dafiamekpo, MP for
No,
South. Oh, Nanabi, you want to
Ben, 30 seconds, Ben.
Okay, go ahead.
Ben, you see, the law you read, that is why I'm saying that the president did not have representation. He keeps repeating it. And again, let me say that it is not in his bosom determine whether the Attorney General was wrong or not. I've said that there are appropriate platforms. They can go there. But the Attorney General is not resigning today. He's not resigning tomorrow. Those evil machinations is not going to work.
Wonderful. Thank you, gentlemen. I will thank you and come to a law lecturer to get his views. So I've been speaking to Roxanne Nelson Dafiamekpo, who's the MP for South Dai, a member of the NDC, and then the national organizer of the MPP, Nana Boakye, both gentlemen lawyers. When we come back, we'll speak to Professor Apiaje Etua, who is a law lecturer at the Faculty of Law, University of Ghana, for his views on the matter. Stay with us. So we'll speak to Professor Apiaje Etua, who teaches at the Faculty of Law, University of Ghana, to explain to us his understanding of how this case has been complicated by the new revelations, where that leaves the case itself, because as you know, it's like the matter is now in the public domain, and of course, where this leaves the current Attorney General. So, Prof, thanks for joining us on The Point of View.
My pleasure.
So
Thanks for having me.
Fantastic. How closely have you been following this particular case? Is it something you've been interested in, or is it the revelations around the Attorney General that have piqued your interest in the matter?
Well, the revelations around this has piqued my interest about how the Attorney General has sought to conduct the case, and which has led to all the revelations that are coming out, and press conferences and press releases being churned out by the main two political parties in the country.
Have we seen anything like this in the past few years in terms of an Attorney General directly involved in prosecuting a case coming under direct fire for his personal involvement with one of the accused people in a case? Is there anything in our recent political legal history that points anything close to this?
Not in our recent political history that I know of, but I recall during the days of a former dean of the School of Law, during the time of Mr. Amisa, there was a similar case that involved, a plea bargain is not something new in our criminal justice system, but it was only applied in a limited extent. And in the Ohinijan case, I recall in class that there was a case, a situation where the Attorney General of the time, Mr. Amisa, conducted some sort of interview with Mr. Ohinijan, and that actually led to his resignation from office.
So that would be the most recent matter. So in terms of what we are discussing, have you per chance listened to the tape yourself? Because I know the NDC chairman held a press conference and played a 60-minute tape, although he interrupted this. And the tape has also been played in various sections in the media. Is this something you've actually listened to yourself?
Yes, I've had the opportunity to listen to the 16-minute tape.
And what do you make of it?
I think it's an unfortunate situation where the Attorney General has plunged himself into an embarrassment for not only for himself personally, but for the office of the Attorney General, because there are a number of situations where what is captured on the tape indicates violations of the ethics of the profession, and which may even go into the realm of violations of criminal law.
Wow. Do you care to elaborate? I recall the NDC made specific reference to 4 things. They said he was doing witness tampering. They said conspiracy against an accused person, professional misconduct, and then they also talk of fabrication of evidence to pervert the court of justice or the course of justice. Listening to the tape, what did you get in terms of what possible infractions he could have committed?
First of all, there was the issue about how the Attorney General was trying to intervene and to cause the third defendant, Mr. Japa, to coerce him more or less to change the plea, sorry, not the plea, but the information relating to the case in such a way that it would implicate the first defendant, who is a minority leader in Parliament, so that he could be found culpable for the charges leveled against him. And the way this was initially played out as a part of the plea bargaining process is certainly something that is not right, and it goes against the legal profession, that's the Professional Conduct and Etiquette Rules 2000. And then we also look at the fact that he wanted to ask Mr. Japa to ask for an excuse duty, and the excuse duty, which also is something that wasn't right, or it was something that was being fabricated in order to prolong the case for him to be present in court when the case, when the accused would be giving his evidence. And so this is also another area where it is professionally wrong for the Attorney General to have done that. And it seems he knew what he was doing was wrong. That is why at a point in the recordings, he said that, "I hope I'm not being recorded." So that tells you that he knew what he was doing was wrong, but he wanted to do it for a particular motive that it is not clear what the motive was. But certainly he was acting in violation of the rules of the profession.
The fact that he was speaking to one of the accused persons, is that in itself an issue? Because I've heard people say that the only way a party or a lawyer from the other side can speak to a person in a case like that is in the presence or through the accused person's lawyer. Is that also an issue? Or if this were within a plea bargaining conversation, then it's regular for a lawyer to be speaking to the client on opposite side alone, directly?
Either way, whether it is the plea bargaining situation or in a regular court process, either way, so long as there's a lawyer involved in the case, whereby the accused is represented, you cannot go behind the lawyer and speak directly to the client. In most cases, it is the two lawyers, that is from the prosecution side and then the defendant side, who communicates, and then they will disclose the information to the clients, or they may agree that all of them should come together and speak together. So in this case, going behind the lawyer of the accused person, whether in the plea bargaining situation or in the normal course of a court trial, in either way, the Attorney General was wrong in what he did.
So you're saying there are issues of misconduct and even possible criminality. Are we going to be bold enough to say that, or this is more borderline issues?
It could come to a case of criminality, because we know that in the legal profession and in the judicial process, if an accused person lies, we call it perjury, or there's fabrication of the facts. And that is what the Attorney General was coercing Mr. Japa to do. And so it is a serious offense. It's a violation of the criminal law, and it's also a violation of the ethics of the profession.
What we've been told from at least the side defending the Attorney General is that the tape has been doctored. In fact, Mr. I think Frank Davis, he said that the original tape, according to the people who played it, is 26 minutes, and that playing only 16 minutes is self-serving and the tape is doctored. Does that matter? Or, is that something that should be strongly considered in this discussion? Or the 16 minutes we heard in and of itself tells its own story, irrespective of what was cut out?
Well, I think the tape as it is now, the 16 minutes or so, tells a story. It helps to put, before the tape was released, some of the information we had were hanging in the air. And so it was responding to questions. It was more of an if it is so and or if it is not so. But the release of the tape helped to put some information together. So whether it was doctored or not, it is clear on the record that the Attorney General was attempting to influence Mr. Japa to issue some information which would have implicated another defendant in the case. And so, and unless the NPP is saying that the voice is not the voice of the Attorney General, then that will be a different matter. But of course, I'm not an expert on determining what the voice of a particular person, but I think on the face of it, it seems clear that it was the Attorney General who was speaking. And if you also listen to the MPP press release or the conference, they were talking about the fact that some of the information have been removed and so on. But I think what we have, we are able to piece them together and come to some conclusion that at least in these three situations that I mentioned, the Attorney General knew that what he was doing was wrong, and what he was doing violates the ethics of the profession. It also could be criminal. And I think another thing to note is that he was trying to hide behind the plea bargaining issue that, when you are talking about plea bargaining, there's a possibility that there's one party in the case, especially if we have a number of accused persons. One of them may be a big fish, if you like, and others smaller fishes. And so the prosecution may want to nail the big fish and ensure that if he is convicted, it will make a big case, or the prosecution would have been deemed to have had a successful prosecution of the matter than if it relates to the smaller fishes, because some may be about the crime itself, and then the other accused persons' cases may relate to being either as accomplices in the case. And so in that situation, the prosecution may engage in a sort of plea bargaining that will lessen the charge for some of these smaller fishes, if you like, and then make sure that they give evidence that will make sure that the first defendant in this case, who seems to be at the center of the case, will be found guilty. And so the argument being made is that it was part of the plea bargaining. But if you go on that tangent, there are a number of stumbling blocks which clearly shows that the Attorney General is not being truthful, because in a plea bargaining process, the rules are clear. He himself is responsible for drafting the law, and he himself has organized meetings and trainings and so on. So he knows the plea bargaining process that is he tried to initiate was to cause somebody to lie, and that is perjury. When you are plea bargaining, you are saying that somebody has critical information that can help the case, and this can be given by one of the parties in the suit. And so I'm lessening the charge for that person so that he will in turn provide that information that will enable conviction to be attained against that particular party in the suit. But that is not what happened here.
So that was Professor Apiagyei Etua speaking to us on the point of view on this very controversial ambulance case that has really gone beyond the court now. Earlier on, I spoke to Roxanne Nelson Dafiamekpo, lawyer and MP for South Dai, and lawyer Henry Nanabuache, who's the national organizer of the MPP. Hope you've learned something and the matters are clearer following this discourse. Thanks for watching. We'll see you next time. Bye-bye.